Hi, my name is Goldman, and I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues. Please subscribe to our channel. Today we're going to talk about dividing the assets. You have to understand that the general proposition in Michigan is that the court's going to try to divide the assets equitably, sometimes equally, in order to make it fair. Now, you have to understand that fair doesn't always mean equal. It doesn't mean that they take something that's worth $50,000 and they give 25 here, 25 there. Why? Well, let's say you have a bank account that is 50,000, but 30,000 was in the account before the marriage. The court is more likely to look at that as an account of 20,000, not 50, and give 10 apiece on the theory that the part that was accumulated before the marriage is not marital property. So the court will try to do things equitably, which means fairly, but not necessarily equally. Now, if you want to make sure that you get a fair division of the assets, number one, make sure you have an agreement as to the value. If you think that somebody's saying an asset is worth more or less than it is, make sure your lawyer knows about it. You can bring in experts to determine what the value is. Now, a bank account or a 401k or something, that's usually easy to tell. But sometimes we can't tell the value of a business. Sometimes one person thinks it's worth $1 million, the other one says it's not worth anything. You know, there's always that issue, and sometimes expert testimony is required to determine the fair value. So if you think you're not getting fair value, you got to bring this to your lawyer's attention, and then the two of you have to discuss, should we retain an expert to evaluate the home, to appraise it, to evaluate a business, to appraise that, to do what's necessary to give the court what it needs in order to determine A, actual value, and therefore B, how we split it. If you have any questions about that, reach out. We'll be glad to help you out.